Hey everyone, and welcome back. Tonight, we're stepping back in time way back to a world where a pig could be paraded into a courtroom, dressed in human clothes, and stand trial for murder. Imagine the scene, the nervous shuffling of the villagers, the hushed whispers, the judge in his robes, and there, squealing softly, a swine accused of a heinous crime. You can almost smell the damp straw and feel the tension in the air. This isn't some outlandish fable. These were very real, very public legal proceedings where animals, from tiny weevils to rampaging bulls, were hauled before human tribunals. So, before we dive in, if you enjoy exploring the delightfully absurd corners of history, take a moment to like the video and subscribe. It really helps the channel grow. Let me know in the comments where you're retuning in from and what time it is for you. Now, dim the lights and let's begin our journey. Picture yourself in an ancient, sun-baked clearing. The air is thick with the buzz of insects and the murmuring of a small community gathered around a makeshift altar. This isn't a picnic, it's a plea, a primitive form of legal action against an animal. You see the worried faces etched with the toil of agricultural life staring at a small, ordinary-looking field mouse caught in a simple trap. Its tiny eyes blink rapidly, completely unaware that its very existence has caused a crisis. Before formal courts or written laws, when humanity was still largely tethered to the rhythms of nature, the line between man and beast was often blurred in the realm of justice. You're witnessing a moment where a pest, a creature that consumed precious grain, wasn't just exterminated. It was engaged with, addressed, almost reasoned with. It's a fascinating, if somewhat bewildering, peek into the early human psyche. They weren't just killing vermin. They were seeking balance and restoring order, even if that order was based on a belief system we might now find utterly fantastical. Think about it. For these early communities, a plague of locusts wasn't just a natural disaster. It could be seen as divine retribution, a curse, or even a deliberate act by malevolent spirits embodied in the swarm. So, how do you deal with that? You don't just swat them away. You appeal, you threaten, you conduct rituals, you even put them on trial. You're standing there, feeling the weight of their desperate belief, as the village elder, with a solemn expression, pronounces a kind of banishment or curse on the offending creature. It's less about punishment in our modern sense and more about exorcism, a plea for the natural world to realign itself. Historians still argue whether these early animal trials were genuine legal proceedings or simply elaborate forms of pest control cloaked in ritual. You can feel the ambiguity in the air, the blend of pragmatism and profound superstition. Is this a symbolic gesture to appease the gods, or a nascent understanding of justice extending beyond the human? Perhaps it's both. You watch as the mouse, now released, is gently but firmly guided away from the fields, an implicit warning delivered. It's almost comical if it weren't so deeply serious for the villagers. As settlements grew and societies became more structured, so too did their legal frameworks. And guess what? Animals didn't get off the hook. Fast forward a few centuries, and suddenly you're in ancient Egypt. Here, you find an interesting legal precedent. Observe the meticulously planned agricultural cycles, the reliance on the Nile, and the veneration of certain animals. A crocodile, for instance, might be seen as an embodiment of Sobek, the god of fertility. But what if that crocodile decides to snack on a local fisherman? The response wouldn't be a trial in our sense, but a careful, ritualistic approach, possibly involving offerings or an appeal to the priests. It's a subtle but important distinction in the progression of animal law, showing a society that understood its profound, even deadly, connection to the animal kingdom. A more concrete historical fact comes from ancient legal codes, like the Code of Hammurabi. While not trials where animals defended themselves, these laws held humans accountable for the actions of their livestock. If your ox gored someone, you faced the consequences. But the idea that the ox itself possessed moral culpability, that was a step further, and one that many ancient societies, while respecting or fearing animals, didn't quite take. Then there's a quirky tidbit from even earlier, from prehistoric cave art. You might see depictions of hunters and prey, but sometimes you catch a glimpse of something more symbolic. Anthropologists theorize that some of these images weren't just about the hunt, but about understanding the spirit of the animal, perhaps even placating it after a kill. Peering at faded ochre paintings, you're trying to decipher the unwritten laws of an almost unimaginable past, where the spirit of a bear might demand respect, or even a form of spiritual recompense for its death. It's a very different legal system, rooted in animism and a deep, intuitive sense of ecological balance. Let's ponder the philosophical underpinnings of these early interactions. Were they truly attributing free will and malicious intent to animals? Or was it a more sophisticated, symbolic way of dealing with the unpredictable chaos of the natural world? The distinction is crucial. If a wild boar ravages your crops, is it a delinquent or simply acting on instinct? For early humans, that line was probably fuzzier than we imagine. They lived in a world where the supernatural was interwoven with the mundane, where a rogue animal could easily be interpreted as an agent of a vengeful deity or a sorcerer's curse. You can almost hear the rhythmic chanting of shamans, feel the pulse of the drum as communities tried to make sense of and exert control over their environment. When a wolf pack continuously preyed on their livestock, they might not just hunt the wolves. They might try to reason with them, or even perform a ritualistic excommunication from the village lands. It was a way of projecting their own social and legal structures onto the natural world, a desperate attempt to bring order to chaos. So, you're beginning to understand that these weren't just simple-minded folks. They were complex thinkers grappling with profound questions about existence, responsibility, and the boundaries between human and non-human. And they did it all with a straight face, even when dealing with a chicken accused of laying a strangely shaped egg, a true crime in some medieval villages, as we'll soon discover. But for now, just soak in the ancient wisdom, or perhaps the ancient bewilderment. We've only just scratched the surface of this bizarre legal history. Stay with me, because things are about to get even weirder. Imagine stepping out of a time machine, not into a grand castle or a heroic battle, but into the middle of a bustling, and let's be honest, pretty smelly medieval town square. The air is a cocktail of wood smoke, sweat, and livestock, but something strange is happening. A crowd has gathered, not for a market day, but for a trial. And the defendant, standing nervously before a tribunal, is a rooster. Welcome to the bizarre and utterly fascinating world of medieval animal trials. For about 500 years, from the 13th to the 18th century, European legal systems regularly put animals on trial for crimes. And I'm not talking about some quirky village prank. These were formal legal proceedings taken with deadly seriousness. Let's go back to that rooster. In 1474, in Basel, Switzerland, a rooster was accused of the heinous and unnatural crime of laying an egg. In the medieval mind, this was no simple biological anomaly. An egg from a rooster was considered an egg of the devil, a potent ingredient for witchcraft. The poor bird was found guilty and, tragically, burned at the stake. It's hard for us to wrap our heads around, right? How could they possibly believe an animal had criminal intent? Well, that's the key. In their worldview, the line between the natural and supernatural was blurry. Animals, especially those that harmed people or property, weren't just acting on instinct. They could be agents of the devil, possessed by demons, or simply have a malevolent spirit of their own. They were seen as having a form of moral agency, and if you have agency, you can be held accountable. These trials weren't just kangaroo courts, they were meticulous. Court documents that still exist today detail trials for pigs, cows, horses, and even insects like weevils and rats. They followed proper legal procedures with summonses, witness testimonies, and formal sentences. Scribes would sit there, quill in hand, dutifully recording every grunt and squeal as evidence. One of the most mind-boggling aspects is that some animals were even given a lawyer. Can you imagine being the defense attorney for a pig accused of murder? What's your opening statement? Your Honors, my client is ... well, a pig. He was simply acting on porcine instinct. The absurdity is almost comical, but it shows how earnestly they tried to apply their legal principles to all living things. Historians still debate whether this was a genuine attempt at justice or just legal theater to make the inevitable guilty verdict seem legitimate. Pigs were frequent defendants. Actually, they often roamed freely through villages, and tragically, there were cases where they attacked and killed infants. The horror and grief in a small community would have been immense. So, the pig would be arrested and put on trial. You might see it in the courtroom, maybe with a bizarre human-like cap on its head, tethered to a post. The prosecution would present its case, and the pig's grunts and snorts might be interpreted as defiance or even a confession. The sentences were grimly parallel to those for human criminals. Execution by hanging or burning was common. It wasn't just about punishment, it was a ritual to restore cosmic order. The act of a pig killing a child wasn't just a tragedy. It was a tear in the fabric of their divinely ordered world, and the legal system had to patch it up. Sometimes, the court would order that the convicted animal's body be destroyed, not eaten, severing its last tie to the community. The spectacle was part of the point. Imagine a procession leading a condemned pig to the gallows. It was a public performance of justice, a warning to man and beast alike that the social and divine order would be upheld. It was about creating a sense of control in a world that often felt chaotic and terrifying. The church was also heavily involved, especially when it came to pests. It wasn't practical to put every single locust or caterpillar on trial. So, what did they do? So, these trials weren't just the result of ignorance. They were the logical conclusion of a worldview where humans, animals, and the divine were all tangled together in a single moral and legal framework. When a creature, great or small, stepped out of line, it disrupted the entire system. Whether it was a murderous pig or a supposedly demonic rooster, the court stepped in to set things right. It's a baffling, sometimes horrifying, but undeniably incredible chapter of our history, reminding us that the concept of justice can take some very strange forms indeed. Thanks for watching. If you found this dive into history as wild as I did, don't forget to hit that like button and subscribe for more strange tales from the past. See you next time. Last time, we delved into the bizarre world where a single pig could stand trial for its crimes. But now, I want you to shift your focus. We're reliving the relative sanity of a courtroom with one animal defendant and stepping into a medieval village square where the accused are. Well, they're everywhere. We're talking about gnats, weevils, slugs, rats, even entire armies of caterpillars. The air isn't thick with the tension of a single accused animal. It's humming, skittering, and crawling with the presence of countless, tiny, anonymous offenders. The villagers aren't holding up a single insect for judgment. They're pointing to fields of ruined crops, 2 granaries emptied by unseen thieves. This isn't about one bad apple, it's an invasion, an agricultural apocalypse on a miniature scale. And faced with this crisis, their only response is to throw the full weight of their legal and spiritual power at these tiny, relentless adversaries. Just try to imagine the logistics. Think of the town crier, his voice cracking with the sheer absurdity of it all, standing in a field and shouting. By order of the court, all rats residing within this parish are hereby ordered to appear before the magistrate on the 3rd Tuesday after the full moon. Or maybe they just nailed the summons to a tree, a formal legal notice for the local insect population. It sounds like a comedy sketch, but beneath the humor lies a very real, very raw desperation. For communities teetering on the brink of starvation, every tool had to be used, even the law. And this isn't just speculation. We have official historical records detailing these trials. In 16th century Switzerland, for example, there are well-documented cases where swarms of weevils or caterpillars were formally summoned to court. The charge: devouring crops and destroying vineyards. When the insects predictably failed to show up, they were found guilty by default. And the punishment, often, it was a formal excommunication by the church. Sometimes, this was followed by a decree ordering them to leave the area and relocate to a designated, barren plot of land. You can almost hear the priest intoning, "Go forth, ye creepy crawlies, and bugger off to that rocky field we've set aside for you." Picture it, a priest in his full robes standing solemnly before a field decimated by slugs. He's not just praying for a miracle, he's engaging in a legal and spiritual battle. He recites a formal indictment listing the specific damages caused by the slugs. He then issues a warning, giving them a few days to leave on their own. If they don't comply, the full weight of ecclesiastical censure excommunication will fall upon them. It's this incredible blend of a courtroom drama and divine intervention, all driven by the desperate hope that God's law, when spoken by his earthly agents, could compel even the most basic of creatures to obey. Now, here's where it gets even stranger. In some of these past trials, the accused were actually given a lawyer. Yes, a human lawyer was appointed to represent the interests of bugs and rodents. Their job was to argue on behalf of their non-human clients. You can just imagine a flustered medieval lawyer standing before a judge pleading, "Your Honor, my clients, the slugs, are merely fulfilling their divinely ordained purpose. They are God's little janitors, consuming that which is decaying." Can we truly hold them accountable for their natural, God-given instincts? Historians still debate if this was a genuine attempt at fairness or just a way to make sure the whole legal process felt legitimate, even when prosecuting a beetle. The lawyer's bill must have been a sight to behold. Consultation with caterpillar colony, 3 hours. Drafting closing argument on behalf of weevils, 5 hours. It's mind-boggling. So, what was the logic behind all this? In a world saturated by a Christian worldview, everything in nature was God's creation. If animals or insects were causing widespread destruction, it couldn't be random. It had to mean something. It could be a test of faith, a divine punishment for the sins of the community, or even the work of the devil. Therefore, tackling the problem required more than just traps and poison. It required a spiritual and legal solution. By holding a trial and issuing an excommunication, they weren't just trying to get rid of pests. They were attempting to restore balance to a disrupted divine order, to bring the world back into alignment with God's will. The concept of jurisdiction was also fascinating. When prosecuting a swarm of field mice, the court had to define the geographical limits of the crime scene and, more importantly, the exile zone. They weren't just shouting "go away," they were drawing lines on a map, telling them precisely where they were no longer welcome and where they were permitted to go. It was a profoundly human act, trying to impose our boundaries, our laws, and our sense of order onto creatures that live in a world without them. You have to feel the sheer desperation that drove these people. Imagine watching your family's food supply for the entire year wither and die, all because of an infestation you have no modern tools to control. In an age before science gave us a real understanding of ecology, turning to the courts and the church wasn't just a quirky option. For many, it was the only option. It was a way of seizing some form of control, however symbolic, over forces that felt completely overwhelming. Beneath all the absurdity, you find a profound human story of struggle against the harsh realities of nature. These trials also served a vital social purpose. They were public spectacles. They brought the community together against a common enemy, reinforcing social bonds and shared beliefs. By taking part in this ritual, even as a spectator, you reaffirmed your place in the community and your commitment to its survival. It was a collective declaration of we're all in this together, even if this involved taking a beetle to court. It was a way for the community to process its anxiety and fear, turning it into a structured, communal activity. And of course, after all the legal and spiritual avenues were exhausted, what happened? The villagers would bring out the traps, the nets, and the poisons. But for them, the trial wasn't a failure. It was a necessary first step. It was a way of legitimizing the physical fight that was to come. It was a declaration to God and to themselves that they had done everything by the book. They had given the pests their day in court. They had offered them a chance to leave peacefully. And now, with their conscience clear, it was time for some good old-fashioned extermination. It's a remarkable window into a worldview where the line between prayer and prosecution was as thin as a beetle-less wing. Thank you so much for joining me on this deep dive into one of history's most peculiar legal practices. If you enjoyed this, please hit that like button and be sure to subscribe and ring the bell so you don't miss our next exploration into the weird and wonderful corners of the past. See you next time. We've journeyed through the bizarre history of animal trials, from medieval courtrooms where pigs stood accused of murder to swarms of insects facing excommunication. The scent of old parchment and the echoes of peculiar verdicts are fading, and we find ourselves back in the present day. But the long, strange shadow of these historical trials still stretches over our modern world, influencing how we think about animals, ethics, and the law in ways you might not expect. The courtroom is still here, but the defendants are no longer a pig in a wig or a swarm of weevils. Yet, the core questions asked in those ancient proceedings reverberate in surprising ways. While we no longer drag a cat into court for meowder, the underlying debates about animal responsibility, human accountability for animal actions, and the very concept of animal rights are more relevant than ever. Think about it. The decline of formal animal trials wasn't just a random shift. It coincided with the Enlightenment, that great intellectual awakening in the 17th and 18th centuries, as reason, logic, and scientific inquiry began to replace superstition. Our understanding of the natural world transformed. Scientists started to unpack the complexities of animal behavior, and it became increasingly clear that attributing human-like malice or moral culpability to a pig or a rat was, frankly, absurd. The legal system, though slowly, began to shed these archaic practices, deeming them irrational. You can almost hear a collective sigh of relief from the entire animal kingdom, can't you? Finally, says the rooster, I don't have to worry about being burned at the stake for crowing at the wrong time. But have the core issues really disappeared, or have they just put on a modern disguise? Consider the phenomenon of dangerous dog laws. These are legal proceedings where a dog's actions are scrutinized, and its future, sometimes its very life, hangs on a judicial decision. Of course, the owner is held responsible, but the animal's behavior is still the central focus of the case. You'll hear lawyers arguing about a dog's intent. Was it aggression or fear? Was it provoked? Does any of this sound familiar? It's a modern, rationalized version of the same fundamental struggle, trying to understand animal agency and responsibility within a human legal framework. It seems our deep-seated need to impose order, even on the non-human world, is an instinct that just adapts with the times. This journey from ancient rituals to modern court cases is incredible. In the past, these trials were often about appeasing angry gods or restoring a perceived divine order. A pig that harmed a human had disrupted the natural and spiritual balance, and a trial was necessary to set things right. The law was a tool to reassert human dominance over a chaotic natural world. But now, the conversation has shifted dramatically. Today, we talk about animals as sentient beings. We discuss their psychological well-being. We even debate whether certain animals, like great apes or dolphins, deserve a form of legal personhood. The very existence of animal cruelty laws, a relatively recent invention, stands in direct opposition to the premise of medieval animal trials. This is the great reversal. In the past, the animal was the offender. Now, in the eyes of the law, the animal is often the victim. Our focus has shifted from punishing the animal for its perceived crimes to protecting it from human mistreatment. This change marks one of the most profound ethical advancements in our relationship with other species. That collective sigh of relief from the pigs and roosters, it just got a whole lot louder. Yet, we shouldn't just dismiss those old trials as foolish history. They offer a valuable mirror to our own societies. They remind us that our understanding of animals is always filtered through our own cultural, religious, and scientific beliefs. They highlight our powerful human desire for justice and order, and our attempts to make sense of a world we don't fully control. These trials show just how differently human societies can interpret the same fundamental interactions between people and animals. Close your eyes for a moment. Picture a dark, medieval courtroom with a shackled farm animal standing before a solemn judge. Now superimpose that image with a modern scene, a brightly lit adoption center at an animal shelter where volunteers work to find a loving home for a rescued dog. The contrast is stark, yet the connection is undeniable. In both scenes, we are grappling with our role and responsibility towards the animals we share this planet with. We are still trying to understand, to manage, and to define our relationship with them. The journey from prosecution to protection has been long and winding, filled with bewildering absurdities and moments of profound ethical realization. The story of villages putting animals on trial isn't just a quirky historical footnote. It's a foundational chapter in the ongoing, ever-evolving narrative of our relationship with the incredible, complex, and often mysterious world of non-human beings. It shows us how far we've come and reminds us that the conversation is far from over. We saw animals being prosecuted, convicted, and even executed with all the pomp and circumstance of a human trial, but history is never a straight line. Today, we're exploring the fascinating counterpoint, the moments when empathy, legal precedent, and a sprinkle of common sense began to seep into these strange proceedings. Picture a courtroom, a bit more refined than the ones we've seen before. The arguments are more nuanced. The defendant, a sow, is accused of injuring a child. But this time, something is different. Instead of immediate condemnation, a voice cuts through the solemnity. Perhaps it's a bold lawyer, or maybe a compassionate cleric. Your Honor, the voice asserts, can this creature truly be held accountable for an act born from instinct, or perhaps from fear? This is where the story takes a turn. We're about to witness the first cracks forming in the monolithic belief that animals were always driven by malevolent intent. One of the most famous examples of this shift comes from 16th century France and a jurist named Barthélemy Chassigny. He became a legal superstar for his ingenious defense of a group of rats accused of destroying a barley crop. His arguments were surprisingly modern and utterly brilliant. First, he argued that the rats couldn't possibly appear in court because the journey was far too perilous, with all the cats lurking about. He then claimed his clients hadn't received a proper summons, as the notice was only posted in the village and couldn't be expected to have reached every rat in the district. But his masterstroke was suggesting that the crop damage might have been an act of God, a divine punishment for the villagers' own sins. He effectively turned the case on its head, shifting the blame from the rodents to the humans. You can just imagine the stunned silence, followed by murmurs rippling through the courtroom. The sheer audacity. It was a clever maneuver that hinted at a growing sophistication in legal thought. It wasn't just about clever legal tricks, though. We start to see arguments rooted in a deeper understanding of animal behavior. Take another case, this one involving a bull that gored a farmer. Instead of simply branding the bull a murderer, its advocate passionately argued that the animal had been provoked. Perhaps the farmer had been careless, or worse, had mistreated the bull, causing it to act in self-defense. This is a crucial step. The conversation was shifting from just the act of aggression to the context surrounding it. It wasn't about absolving the animal entirely, but about introducing nuance. It was a move away from projecting human morality onto animals and a step towards understanding them on their own terms. And this is where things get even more fascinating. The concept of mitigating circumstances began to appear in animal trials. There are actual records of animals being acquitted or given lighter sentences based on factors we de-recognize today. Things like their youth, their previous good behavior, or even the negligence of their owners. Imagine a tiny piglet, barely weaned, accused of nibbling some forbidden apples. Its lawyer might stand up and declare, "My client is but a babe, Your Honor." It lacked the cognitive capacity to understand the gravity of its actions. It sounds almost like a parody of a modern criminal defense, but it was happening. This suggests that some legal minds were beginning to differentiate between an animal's inherent nature and an act influenced by outside forces. They weren't quite ready to abandon the idea of animal guilt, but they were starting to see shades of gray. Historians still debate the true motivation behind these defenses. Were they genuine expressions of evolving legal philosophy, or were they just pragmatic decisions? After all, prosecuting every single animal that caused a problem was impractical and, frankly, often ineffective. But regardless of the reason, we can sense a gradual shift. The rigid, human-centric worldview was beginning to allow for the possibility of animal innocence, or at least diminished responsibility. It wasn't a sudden revolution, but a subtle, creeping evolution in legal reasoning. A significant turning point came with the idea of shifting the blame. Let's revisit that sow, the one condemned for killing a child. Imagine its sentence being reviewed. This time, the argument isn't about the sow's innocence, but about the owner's negligence. Why was the animal allowed to roam freely near children in the first place? The argument might go, this is a huge development. The legal focus begins to pivot from the animal's supposed malice to the human's actual responsibility. You can hear the echoes of modern law in these arguments. The animal, being property, was increasingly seen as an extension of its owner. Therefore, the owner was the one who should be held accountable. This was the foundation for our modern laws about pet ownership and liability. Public opinion also started to play a subtle but important role. While a wild boar rampaging through a village would cause genuine outrage, the community might feel very differently about a valuable workhorse. The pragmatic realities of rural life began to bump up against rigid legal traditions. A horse was essential for farming, a pig was a source of food. A judge, especially after a harsh winter, might be more inclined to spare a useful beast, knowing its execution would only create more hardship for the community. You can almost hear a villager grumbling, "We can't just execute every pig that nips someone. Your Honor, who's going to clear the forest then?" It was a balance between justice, as they saw it, and survival. Ultimately, the entire system began to falter under the weight of its own absurdities. How do you really punish an insect? Sure, a priest could excommunicate a plague of locusts, and that might satisfy a spiritual need, but it did absolutely nothing to save the crops. The sheer logistical nightmare of trying to bring an entire swarm of pests to trial was comical. Can you imagine the size of the defendant's box you'd need for 1,000,000 grasshoppers? The practical challenges and the growing number of acquittals and appeals revealed the deep flaws in the system. These instances of defense, however sporadic, represent a crucial turning point in legal history. They show that even within the strict confines of medieval and early modern thought, there was a growing awareness of the unique nature of animals, their instinctual drives, and their lack of human-like reason. It wasn't animal rights as we know them today, not by a long shot. But it was a definitive step away from treating them as morally culpable beings just like humans. We're witnessing the slow, often clumsy birth of a more nuanced understanding of the animal kingdom within our legal framework. It's like watching a slow-motion collision of legal philosophy and biological reality, and in that chaos, for a fleeting moment, you can see the glimmer of something more enlightened trying to break through the fog of superstition. Thanks for joining me on this journey into the stranger corners of legal history. If you enjoyed this, don't forget to like, subscribe, and hit that notification bell so you don't miss our next exploration. See you next time!